This is Chapter 18 of Criminal Procedure Code 1973, Trial Before a Court of Session. This is part 1 of Chapter 18, and in this lecture, we will try to learn all sections of Chapter 18, that is section 225 to 237, in a very different manner. Come on, join me and enjoy studying law with me. Before I start this lecture, let me inform you that India on the British pattern was having the system of trial by jury, which is now abolished in England and in India as well. Jury system was not just in England or India, it was in every other developed country. It has many drawbacks. It was time consuming because, if you are choosing 10 judges, you have to match each and everybody's free time. And then they used to take their own time in making decisions, checking the facts of the case. It was expensive. It is very obvious to make payment of every member of jury system. Another demerit was that it was emotional. Rather than going into the facts and circumstances of the case, they were going into the profile of the person. Next demerit, effects of media. Yes, media does affect. Even now we see media plays a big and larger role in changing the mindset of a person. Jury system played good role, and it was plea bargaining started by the jury system, and even summary trial was started by the jury system. Anyway, now the jury system is not operative in India anymore. Let's start from the starting that the criminal investigation process and prosecution mechanism in India can be started in any of the following manner: on complaint, reporting, or knowledge of the commission of cognizance offence. Any police officer, even without the orders of a magistrate, can investigate the cognizable case. This is given under section 156 subsection 1 of CrPC. We have already covered that. This is just a brief intro that how the criminal court processes, how the case begins. And in case of failure or inaction of a police officer to investigate a cognizable offence, a criminal complaint can be filed before a magistrate under section 190 of CrPC. I know we have already covered, but then, introduction can be given like this. For taking the cognizance of such offence and on such complaint, the magistrate himself can take cognizance of the case and do the inquiry, or in the alternatives, under section 156 subsection 3 of CrPC, order police to register an FIR and investigate the offence. That was an introduction regarding the criminal mechanism process in India. Now let's cover how to approach court of session. Let's go in flashback. Chapter 2, section 9 subsection 1. The state government shall establish a court of session. This is where it begins. Section 9 subsection 2. The High Court to appoint a judge for court of session. The appointment is not the fresh appointment, but among the senior most judges of the court. In chapter 3, the powers of the courts are given. If you check section 26, it says any offence under the Indian Penal Code 1860 may be tried by the court of session. Check 26, clause A, subclause 2. Students doing LL.B. LM course does not need to go into the depth of such things, but if you are preparing for judicial or UPSC examination, you must know all such things. Next is chapter 14, section 193. It says a court of session cannot take a cognizance of an offence unless it has been committed to it by magistrate. So you see, how are we going to approach court of session? Not directly, but by the magistrate, which it thinks that has the power of court of session only. But there is a rider. Supreme Court has the power under section 193 to order session court to take the cognizance of a case. And there is one another fact. Section 199 subsection 2. The court of session may take cognizance of such offences. Which offences? Defamations. Whose defamation? Write down in the comments. I want every student to write it, learn it. Let me tell you, the defamation case in the court of session shall be taken up only upon a complaint in writing by the public prosecutor. Only in these such cases one can approach a court of session. In criminal procedure code, there are 4 types of trial. First is the trial before court of session under section 225 to 237. This is given under chapter 18. Second is trial of warrant cases by magistrate given under section 238 to 250, which is under chapter 19. Third is the trial of summon cases by magistrate under section 251 to 259. This is given under chapter 20. And the fourth is summary trial under section 260 to 265. This is given under chapter 21. And now we are going to check chapter 18 first. So let's begin with the first part, trial before court of session under section 225 to 237. How to learn all sections of chapter 18, which is trial before a court of session. First thing you must remember that this chapter begins with section 225, conducted by the public prosecutor. Now imagine if it is a cricket. The tournament at session court is conducted by public prosecutor. So remember the word PP under section 225. And the opening is always done by the prosecutor because they are conducting the tournament. So they have the right to open under section 226. So remember the word opening under section 226. Immediately on opening, the court can discharge on the very first day. So remember the word discharge under section 227. If the court does not discharge, then framing is done under section 228. So remember the word framing under section 228. Now the question comes, what if person or the accused accepts his wrongdoing, that he is guilty? It is very obvious the court will convict on plea of guilty under section 229. So remember the word guilty under section 229. If nothing happens, then the court has to proceed and fix date for prosecution evidence. So remember the word PE under section 230. Next is section 231, that is evidence for prosecution. Now EP is the word to remember under section 231. Section 230 PE, section 231 EP. So I don't think it's complicated. You must remember each section wise for this chapter 18. Now so much of PE and EP has been done, so remember the next is acquittal under section 232. Now next part comes the entering upon defense under section 233. Please don't argue because under section 234 arguments are given. So remember the word arguments under section 234. When arguments are done, then comes the judgment under section 235. It can be for the acquittal or the conviction. So remember the word judgment AC. AC is either acquittal or C for conviction. Now don't forget previous conviction. It can enhance the punishment under section 236. So remember the word PC, that is previous conviction, under section 236. And to end with the knowledge of the procedure in case instituted under section 199's subsection 2. And remember the word procedure under section 237. Now let's try to learn these sections through flowchart. As we know that in session court, the case is taken up or conducted by the public prosecutor and its opening is done by the prosecution. Upon such opening, the session court or the court of session, as we may call, the judge can discharge the case, and if the matter is discharged, it is obvious the case ends. But if the judge thinks that matter can be taken up, the framing of charge will be done, and upon such framing, if the accused accepts his guilt, obviously the case ends again. But if he does not accept his guilt, upon framing of the charges, the judge will give date for prosecution of evidence. And upon prosecution of evidence, evidence for prosecution will be taken up. After such evidences, if the judge considers that such evidence does not hold accused to be guilty, that he had committed the crime, the judge can order for acquittal of the accused. But on other hand, after taking such evidence, if the judge thinks that it looks like he has committed the crime, and upon entering upon defense, the next stage comes the argument stage by the prosecution and the defense counsel, and after all such process comes the judgment part. The judge can acquit or convict as the case may be. And if there is an previous conviction against the accused, obviously this helps in enhancing the punishments. And in the end, the last part that court of session does is Take up defamation cases instituted under section 199 subsection 2. Next, we will cover all the sections in detail, and before that, a little request. Respect elders, love kids. Make this place a better place to live.